Just want to hear something.
A good day for the state.
Yes, it is.
I mean, you are told the court that allowing him to continue to perform parliamentary duties will amount to a constitutional breach. This must satisfy you.
Yes, definitely. And for me, it's an affirmation of long-established principles by the Supreme Court. The Supreme Court had, in earlier cases, decided that the proper time for reckoning whether a person is qualified to contest for parliament is the opening of nominations. The period between the opening and close of nominations. If within that time you're not qualified, you cannot be qualified at all later on. So for me, this is a sound application of a principle of law that has long been established by the Supreme Court in Yeboah against J.H. Mensah way back in 1997 to 98, and then the recent Senator Rollins, where Atuguba established clearly that it is the opening of nominations that should be the determining factor as to whether a person is qualified to stand for election or not. And I think that there ought to be even application of the law. There ought to be an equal application of the law. The same fate befell Adamu Dramani Sekande. He was not qualified at the time that nominations were opened, and we don't know what happened to him. He was subsequently declared ineligible, and for that matter, his seat was taken away. So there ought to be even application of the law. If it happened to Adamu Dramani Sekande of the MPP, yes, it also has to happen to a gentleman of the NDC who has also fallen foul of the same law.
What happens to the people of Assin North? Because the court says this should remain in force until the substantive matter is determined.
Yes, definitely. So it means that as the High Court that had earlier on held, the seat for me, the people of Assin North will not be represented. And I think that for all these legal gymnastics that have been employed by the lawyers for Assin North, perhaps the by-election should have been conducted long ago. And I, in my view, think that there's even nothing in the way of the Electoral Commission to declare the seat vacant. The High Court has ruled, given a judgment, determining the status of the gentleman as not qualified to have stood for election, and had actually cancelled the election conducted in the Assin North constituency. And the Court of Appeal subsequently struck out this appeal for non-compliance with the rules of the Court of Appeal. So there's no appeal pending. And I think the way is clear. But of course, the Supreme Court has ordered an expedited hearing and determination of this matter. Yes, I believe that the Supreme Court hearing definitely will also affirm all the principles of law that I have indicated had early on been established by the courts of Ghana.
As Attorney General, it must really worry you that between now and whatever time that the Supreme Court would have had the substantive matter, the people of Assin North, their right to representation would have been taken away from them.
I don't think that it is any right for representation which has been imperiled at all. I mean, it must be established clearly that the Supreme Court has always exercised its powers to grant an injunction in constitutional matters. Way back in 1996, the Supreme Court granted an injunction against the MPP in the case of Rosemary Kwame against the MPP. NPP was injuncted from proceeding to elect a candidate on account of the fact that the Supreme Court has exercised the power to grant an injunction. It's a court of law and equity, and therefore the main basis for determining whether an injunction ought to be granted is whether indeed a clear case of unconstitutionality has been established. And as I indicated in argument to the court, each passing day that the gentleman continues to unlawfully go to Parliament, he breaches the Constitution. So he's a running unconstitutionality. And I think that the Supreme Court is in its right to halt such a patent and running unconstitutionality. Thank you.
So we had the Attorney General, Godfrey Dame, there, basically breaking down what transpired in court.
Congratulations.
Thank you. It's not a matter of me definitely expecting this. It's a matter of the Lord Justices of the Supreme Court having made a determination of the application which was before them. If you say that I knew this was coming, as if I'm a judge, I'm just a lawyer. I present my case before the court and the court rules. Indeed, I'm not a clairvoyant. Well, because of what we had put before the court, my expectation was that the constitution of the land will be upheld, and that the constitution of the land will be given its highest priority. And that is what has happened. One cannot involve in egregious breaches of the constitution and still go around holding himself as a citizen of this country. From day one, when the judgment of the High Court was rendered, it was manifestly obvious that Gyakye Quayson could not hold himself out as a member of parliament. He doggedly went on, was attending on to the business of government. But today, that road has been effectively blocked. You can tread a path for too long, but it doesn't.
Is also minded about the right of his own people, including he himself, to be represented in parliament. This has been the lingering concern from day one of this. How do you reckon the people of Assin North will be represented up to the time that the court would have duly dealt with the matter and fresh elections conducted?
The right of representation is not a stricture by itself. The right of representation is steeped in law. You can't have an illegible person running around as a member of parliament for a constituency when he is not. It obviously leads to a mutilation of the sovereign will of the people of Assin North. They are better off now without someone who is parading as a member of parliament whilst he is not, whilst we await the decision of this court. The mere fact that they don't have to quote a member of parliament at this time does not, in any event, strip them of what they are entitled to as citizens of this country. At any particular point in time, there will be a needed representation from the new Patriotic Party for the Assin North constituency.
Mr. Davis, the AG holds the view that as far as he's concerned, he doesn't think anything actually stops the EC from going ahead to declare the seat vacant and having the by-election takes place. Is that a position that
I won't stray into that logic. The EC was represented in the courtroom. They have a lawyer, and the lawyer will advise them as to the next steps to take. I do not attempt to speak for the EC.
Yeah, but what do you expect to happen?
Well, you also have read the Constitution. As a trained journalist, you've read the Constitution. You know what it means.
It remains till the substantive matter is determined. For now, they do not have an MP. There's a judgment that was final that says he can't hold himself as MP.
So the EC will do what is right by law. Right?
So Mr. Frank Davis, the lawyer for the plaintiff in the case against... okay. Well, we also have a rep for Mr. Gyakye Quayson there.
Your member was not in court today personally, and this was handed down. How do you receive this ruling?
I don't think that it matters whether he was here or not. Let me say that the Supreme Court has given its ruling, but we vehemently disagree with their position. I think that it is a sad day for all of us. That if what it means is that Assin North is also not going to have representation in Parliament for as long as this case lasts. That is a sad situation, because there are precedents in this country. We all remember the case in Ayawaso, West Wagon, where the lady was allowed to stay in Parliament until the final day of the determination of the case. So I thought that the Supreme Court will consider that situation and allow a representation. You see, this is a representation matter. If people have voted for a person, this is a representation matter. They deserve representation in Parliament. And so we thought that when the case is on, we could still have a representation in Parliament. But that is what the Supreme Court has said. The legal team will meet, of course, and also officially know the next step to take. Very well.
So we had Baba Jamal, a member of the legal team of James Gyakye Quayson, speaking at the Supreme Court right after the court restrained the, should I say, erstwhile member of Parliament from restraining himself from holding himself as a member of Parliament for Assin North. Now, spokesperson for the petitioner, that is Mr. Michael Ankoma Nimfa. I believe, this ruling basically, makes you happy.
To some extent, just that the Supreme Court today affirming the constitution of the land, that Mr. James Gyakye Quayson cannot carry himself as the MP for Assin North and go to Parliament until the determination of the substantive case. I think that is good for all of us as Ghanaians, because as a country, we all just incumbent upon each and every one of us to ensure that the law works. And for you to represent the people of a particular constituency, it should be done within the confines of the law. And per the law, if you're a dual citizen, you cannot represent a group or a constituency or constituents in this country. And we all know, and it's a fact, that between 5th and 9th of October 2020, that Mr. James Gyakye Quayson presented his nomination form to the EC. He was indeed a Canadian citizen. So, and that was exactly what the Cape Coast High Court did affirm on the 28th of July 2021. And he should have been in Parliament. He should have been going to Parliament, but he went against the law and went to Parliament, carried on with duties as MP. So today, the court has said that he did not have the right and he shouldn't carry himself as MP and continue to go to Parliament until the final determination of the case. So we are happy that indeed the law has been put in its proper position.
Now you are happy, but aren't you concerned that residents of Assin North currently, and until the substantive case is actually heard, will be without representation in Parliament?
As the lawyer for Ankoma Nimfa, this lawyer Frank Davis, to represent a constituency in Parliament is by law. You cannot just get up and say that I'm representing a group of people in Parliament. So it is the law that is taking its course, that they should go through, anybody who wants to represent the group of Assin North should go through the right procedure and represent them. So it is the law that is working. And I know that very soon the group of Assin North will get the opportunity to elect a new member of Parliament for themselves. So for me, no vacuum has been created at all. Just that the law is being put in its proper position.
Now, Lawyer Frank Davis also alluded to the fact that looking at the rulings from the High Court sitting in Cape Coast and the Appeals Court, it appears the EC, can go ahead and organize a by-election. Do you agree with that, and do you think the people of Assin North would expect this?
He never alluded to that. He never said that. All that he said that, yes, the lawyer for the EC was in court, and he thinks that the EC will do the right thing.
Now, what was the reaction of the plaintiff, to this ruling?
Oh, as I said, for him, he came to court to seek justice. And at the end of the day, justice has been duly served. So he is happy that indeed the law has been put in its proper position. It's incumbent upon every citizen of this country to ensure that the law works. That has been the sole objective of Mr. Michael Ankoma Nimfa, that somebody who seeks to pass laws for me, you, and whoever is viewing to abide by should be the first to uphold the law. He shouldn't embark on flagrant disregard for the law. And that's exactly what happened. That's exactly what James Gyakye Quayson did. That at a point in time, at a material moment that he knew that he was a Canadian citizen, he appeared before an officer of the court, that's a commission of oath, and lied on oath that indeed he did not owe allegiance to any other country apart from Ghana, at a time that he knew that he owed allegiance to Canada. And as we all know, there's a precedence. As it did happen to Adamu Dramani Sakande, at a time that they said he owed allegiance to Burkina Faso and Britain, and therefore he did not qualify to be a member of Parliament for the group of Boku Central. How can Ankoma Nimfa, James Gyakye Quayson, also being a dual citizen, hold himself as the MP for the group of Assin North? The law is no respecter of persons, and therefore, as it did happen to Adamu Dramani Sakande, the same things will apply to James Gyakye Quayson. So Ankoma Nimfa, it doesn't hate James Gyakye Quayson. He doesn't have any ulterior motive. He is performing his duty as a citizen of this land, ensuring that the law works and the law doesn't respect anybody, but it is put in its proper place. And that's exactly what has happened in the Supreme Court, that indeed James Gyakye Quayson should not continue to carry himself as the MP for the group of Assin North and shouldn't go to Parliament until the final determination of the substantive case.
Thank you so much. That's the rep of the plaintiff in this particular case, Mr. Michael Ankoma Ninfa. Basically, the Supreme Court has restrained the MP for Assin North from holding himself as Member of Parliament for the area until the substantive case is heard. My colleague Sixtus Dong Ulo was in court, and he would bring some more light on what transpired, the implications, and other matters. Sixtus, welcome to the Citi Newsroom. Yeah, so a good day in court for the plaintiff and his counsel.
Well, we have to be careful how we use the expression "a good day in court." It will depend on where you stand and how you are looking at it from. But obviously, I agree with you. A good day for Michael Ankoma Ninfa and lawyer Frank Davis and the NPP. This is a good day for them. And obviously, the Attorney General has consistently advocated in court that this was the long-standing position of the law, that if you get into the office of a Member of Parliament through unconstitutional means, you should not be allowed to remain in that office. That has been his argument consistently in court. But it is obviously and definitely not a good day for James Gyakye Quayson and the NDC. This effectively means that the NDC also, if you come down to the politics of it, they are down by one. Let's say, thankfully, Parliament is on recess and they may not need the numbers now, but you can never tell what would happen in the future. There may be the need to reconvene the House out of recess for some emergency business to be transacted, and they would need those numbers. So, of course, it's a good day, bad day, depending on where you are looking at it from. And so, between now and the time that the substantive matter would be discussed or determined by the court, the people of Assin North would have to go without an elected Member of Parliament.
Do we have a clear idea as to when the substantive case itself will be heard? What timelines are we working with here?
We do not have a clear case as at yet. The only directive from the court that we have now is that the parties are to file a memorandum of issues on the substantive matter before the 25th of April. If they are not able to agree on what issues, the issues are simply the questions of law that you are inviting the court to answer. Whether James Gyakye Quayson was owed allegiance to another country or another state besides Ghana, it's that question that the court would be invited to answer, bordering on Article 94(2) of the Constitution 1992. And so between now and 25th, and when the issues are expected to be filed, we still cannot tell exactly how or when the case would be dealt with. Again, the indication we have from this is that the case has been adjourned indefinitely. So until such time that the parties have filed their issues and the court has been re-empaneled to hear those issues, as it stands now, we cannot tell exactly when that would be done.
Okay, now, I mean, for those who are watching, this is the ruling was on the injunction. Talk to us about a substantive case. What exactly is that about?
James Gyakye Quayson came to the Supreme Court with two applications. The first one was for...
That's Michael
Yes, Michael Ankoma Ninfa, I beg your pardon, came to the Supreme Court with two applications that the Supreme Court should interpret Article 94(2) of the Constitution. This article talks about holding office, what should bar you from holding the office of a Member of Parliament and other sensitive offices, specifically talking about owing allegiance to Ghana and other countries. So before you get to occupy an office like the Member of Parliament, the office of the Member of Parliament, you should have demonstrated that you do not owe allegiance to any country other than Ghana. And that is what the matter borders on. From the very onset, and indeed even the angle of the case, the criminal angle of this case that is pending before the High Court, the question remains whether at the point that Mr. James Gyakye Quayson picked up his nomination forms to contest for the seat of Assin North on the ticket of the NDC, whether he was or he owed allegiance to any other country besides Ghana. That's the legal question to be answered here, and that is the matter that is pending before the court. So this injunction was only to, in the meantime, put James Gyakye Quayson out of office, just to ensure that as the Attorney General and the lawyers for Michael Ankuman-Nimfa put it, to ensure that there is no constitutional aberration that the people of Assin North are not taken for granted.
Now, I mean, the ruling was 5-2 majority. I believe. How different is this ruling from other, rulings related to this particular case?
Well, we have seen in instances where decisions have been taken unanimously. In this particular case, we have seen a majority decision. What that simply means is that 2 of the 7-member panel did not agree that James Gyakye Quayson should be barred from representing the people of Assin North whilst the matter is heard. James Gyakye Quayson, the other 2 people, we still don't know exactly how they reasoned on this matter. Indeed, the rest of the court, we don't know exactly how they reasoned on this matter. All we know is that this is the decision that they have made. But as to what informed the decision, we still don't know. We will get to know that later. So in this particular case, we have seen Her Ladyship Agnes Doji dissenting. We have seen His Lordship Nene Amegache dissenting. What that means is that the President of the Court, Jones Doche, Yoni Kulendi Emmanuel, His Lordship, Her Ladyship Gertrude Tokono. I'm trying to recollect all the names of the members of the panel. All of them, there were 5 of them in all. They all agreed. Her Ladyship Mariama Ousu, Professor Henrietta Mensah Bonsu, they all agreed that in the interest of justice, Mr. James Gyakye Quayson should step aside or step down as the Member of Parliament for Assin North whilst the substantive matter is heard. Like I said, we do not know exactly how and why they arrived at that conclusion. We will get to know that later on when they file their reasons at the court registry.
Now, does this bring finality to the call for him to be restrained, or is there room for appeal? If you can educate us.
This is an equitable remedy. As it stands now, like we said, it is only in the interim, and this is a discretionary remedy. In other words, the court had a discretion. This is a ruling that the court gives out of its magnanimity and its own reasoning. So I'm wondering how you would have difficulty with something that the court can choose to decide either ways. You get it? But it is not the end of the matter. You know, for what it's worth, it's not the end of the matter. It's not the finality to the matter. No. It is possible that after all of this, we would see James Gyakye Quayson back in office as the Member of Parliament. But of course, as we have seen the plaintiff applicant in this matter, who is Michael Ankuman-Nimfa, his lawyers hint at every turn, there is the advocacy or the push for the Electoral Commission to strictly work with the judgment of the High Court, by which judgment it would mean that the EC would have to immediately move into Assin North, and conduct a by-election. But all of these are things that we cannot say, with a straight jacket that it is going to go this way. So there's the push for a by-election immediately based on the High Court judgment and based on what they would see as an affirmation by the Supreme Court. But then again, there are other processes that are ongoing, which in the interest of justice, they may just want to hold on with that push. But of course, all these are decisions that lie with other authorities.
I mean, not to belabor the points, but can you remind us of when it's been adjourned to, and also delve deeper into the numbers game, in Parliament, and what the implications will be for, like the various sides?
This case has been adjourned indefinitely. Indefinitely because the parties have been directed to file their submissions on the substantive matter by the 25th of April. Until that is done, the court is constrained, cannot move on. This was just a peripheral issue. This injunction application that has been granted, it was a peripheral issue, even though it has huge ramifications. Okay, so this means that it only gives the court time to be able to look into the substantive matter. So as it stands now, we do not know when the court would be empaneled again to look into the substantive matter. That's number one. Number two, on the numbers game, this again delves a blow on the NDC side. That means that this is -1 for the NDC. Know that the nature of the current parliament, numbers is everything. So NDC had 137, and NPP 137 plus an independent candidate joining, independent member, taking sides with the NPP to form the majority group. Now, if there was any vote on the floor of the House, as we have seen in the time past, this came down to how many members each side could marshal. And this is why the decision that allowed a deputy speaker presiding to be part of the quorum formation and to also vote was so critical that it did not take away from the NPP's numbers in Parliament, even if a deputy speaker was presiding. Now imagine that there's a matter in Parliament, a deputy speaker who is a member of the majority group is presiding. The NPP or the majority in Parliament still maintain their numbers, but that is 138. But the NDC is down by 1. So James Gyakye Quayson would not be in Parliament to cast his vote. That means that the NDC, that is the minority group, would be losing by 1 vote. That means that they are down already. Okay, so the point I made was that it is only maybe good for the minority group that this decision has come at a time that the House is on recess and they may not really feel the impact that much, except where the House has been compelled to come out of recess to take a decision or to make decision on a particular issue, which is something that I'm not sure would happen anytime soon. But if this issue is not resolved before the House gets back from recess, it means that the NDC would be working with 1 down going forward until a determination is made.
Thank you so very much, Sixtus Dongulo, giving us a very in-depth breakdown of what transpired in court today. The substantive case is still yet to be heard, but then the Supreme Court has restrained the Member of Parliament for Assin North from holding himself as a Member of Parliament for the people. Reporting to you from the Supreme Court, my name is Obiose.